here. Our final case for this morning is Sandra Sheridan versus State of Florida Department of Health. Counsel, are you ready?
I sure am.
Okay, please get to it.
All right. I think I'll split it 10 and 5, although I don't think I'm going to need all that.
Okay, great.
Good morning, Your Honors. My name is Jim Garrity. I'm here on behalf of the appellant, Sandra Sheridan. She, of course, lost on summary judgment at the trial court level. We're asking the court to reverse that. This case was a civil rights case at the trial court level. The hearing on summary judgment revolved all around the administrative exhaustion requirements for civil rights claims. There are some very technical principles that deal with the administrative exhaustion concept, and that's reflected in some of the disagreements in what the cases say and what they require. But I think that all of the arguments here and all of the principles that we're asking to reverse this case on can be sort of summarized into 5 basic rules about the exhaustion requirement, all of which we say the trial court violated here. Rule number 1 is that the law regarding administrative exhaustion is quite clear that we don't require aggrieved civil rights victims to do the job of the agencies that are charged with completing that administrative review process. We don't require the victims to do their jobs. Rule number 2, we don't punish aggrieved victims of civil rights issues if the agencies haven't done their job. We don't do that. Rule number 3, quite clear, whether it's a state or a federal civil rights statute, we interpret the statutes in favor of finding a remedy, in favor of allowing the cases to proceed on the merits, and not be tossed out on hyper-technical grounds. Rule number 4, we don't use knowledge gained in hindsight and then imbue that to the aggrieved victim and say that based on that information, which we know now, but we didn't know then, that the victim should have done something differently back at the time.
Let me ask you a factual question, a representation made in the brief. I think it was your position that it was the plaintiff here was unable to comply with the 90-day right to sue timeline and also the 180-day investigatory period for FCHR. Why was that, since the 90-day right to sue timeline was limited to the federal law claims as opposed to the state claim, which she ultimately filed the lawsuit on?
Sure, great question. I know that there are schools of thought that right to sue letter only applied to the federal claims and that something else later on might be done with the state law claims. I've been doing civil rights work for 30 years. I don't know, quite frankly, one, that I agree that the right to sue letter in a work share agreement state where one or the other, you know, it's like the post office. If I drop my mail off at Centerville or downtown, it's all received by the post office. The same rule applies in Florida. There's a work share agreement that says that you drop it off at the FCHR, you've dropped it off in Miami at the EEOC, and vice versa.
If you check the right boxes.
If you check the right boxes.
And the boxes were all checked.
You bet, if you
Okay.
dually file. So in this case, we dual filed. We say that we, in fact, as a factual matter, filed with the EEOC and we filed with the FCHR. We did that because this is a work share agreement. Now, it's not every case where the EEOC issues a right to sue letter and then the FCHR separately at some point down the road issues its own finalization documentation. That doesn't always happen. I can tell you what we do is when we get that right to sue letter, in my view, that's the clearance from the control tower to take off. That's what we get in these cases, whether it's issued by the FCHR or the EEOC. And as I say, they don't typically each issue one in every case, otherwise there'd be no reason for the work share agreement. They'd each be duplicating their labor every time.
Right. Well, it is interesting that the right to sue letter itself in bold print says it's, you know, limited to the federal lawsuit and there may be other time limits for filing suits under state law. I mean, whether that's right or wrong is a matter of law. That's what the letter says.
It does say that, and I tell you right now, I would never wait any period of time beyond the 90 days. Once I get a right to sue letter from either one of those agencies, we're going to file. And you know, I can tell you from background that there's a huge body of law around whether you filed in time. And you know, you have 90 days from the issuance of the right to sue letter. Of course, if the EEOC mails it out of Miami, we're not going to get it that same day. So courts say, well, there's a 3-day grace mailing rule, even though it says you shall file within 90. The law on that is also very complicated. I'm not sure as I stand here that I would agree that the EEOC's issuance of a right to sue letter in a work share state like Florida, and I also practice in Georgia, they don't have a state agency, we don't have that problem there, but in a work share agreement state, the agreement says, and it's in the record, that the act of one is the act of the other, so we can't take that chance. The other thing I want to stress is that, like I said, it's the right to sue letter is what we get. In this case, we didn't know, and they didn't know, that when the EEOC issued that right to sue letter right away, that they hadn't picked up the phone and called the FCHR and said, hey, we're thinking about doing this, or it's untimely, do you guys want it? No, we don't. We don't know what they said. We wouldn't know. The document that we get is the right to sue letter. We don't get any notification behind the scenes within the agencies as to what kind of communications they'd engaged in. And I respectfully submit that it wasn't until this lawsuit was filed that both parties learned that the FCHR had not had, or at least it says it hadn't had any contact with the EEOC. That's not something we would know. We did everything that was asked of us and nothing that wasn't. We timely filed the charge. We dual filed it. We didn't get in the way of either agency. We didn't, like a lot of the cases they cite, we didn't go to the Florida Commission, which some lawyers will do, and say, give me that right to sue letter, I need it right now. I think that's a fatal flaw in many cases. We didn't do that. We didn't ask them to do anything. So we timely file it. We stay out of their way. We got the right to sue. We timely file. What's troubling about this case is a couple of things. One is that the case law, I think, uniformly says you don't punish the aggrieved victim for flaws by the agency. And we've cited some cases from this court. There was one between the FDOT and the FCHR. We cited a U.S. Supreme Court case, FedEx versus Holowecki. Lots and lots of cases that say you don't punish the aggrieved victim for flaws in the agency's process. Clearly, this was just a mistake that happened behind the scenes between the Florida Commission and the EEOC, over which we had no control and regarding which we had no role.
Well, let me get to, I think, another difficult legal issue, and that is, let's just assume the complaint was prematurely filed because it was filed before the 180 days that FCHR has to investigate. Then the question becomes, is the jurisdictional one. Did FCHR lose jurisdiction? I will confess, I thought the 11th Circuit opinion by Judge Dabena was very persuasive in that regard, and that it's not jurisdictional, and that the court can simply dismiss it, let FCHR do its business, and then it can become ripe, so to speak. But there's other cases that are in conflict with that, the third DCA Sweeney decision. So help persuade the panel, the court, that the 11th Circuit should be followed as opposed to the 3rd District.
Yeah, two arguments on that, and thank you for the question. One is, when I look at everything relating to civil rights claims in Florida or Georgia, I ask myself, what is the overarching purpose of these statutes, and what's the goal, and what has the Florida Supreme Court said is the goal? And it has said consistently, find the remedy if you can. So I start with that kind of mantra, and there's no dispute about that. They say we don't want these cases being bounced on hyper-technical grounds. And again, the case in front of you is one where we did nothing to create this situation. So on to the 11th Circuit's question. Yeah, I think there's plenty of cases that follow the 11th Circuit. They say this isn't and shouldn't be jurisdictional. There are lots of remedies. In the event you even have a defendant that says it suffered prejudice, I don't think you have that here. There's no demonstration of prejudice. This case sat largely idle for long periods of time. But the courts have said, I think the better reasoning is it's not jurisdictional, and courts have done a couple of things. One, they've dismissed the case and say, go back, fix it if you can, or two, abate it. And that's a common approach that a lot of trial courts will take in a variety of circumstances, not just civil rights, where there's been something that's maybe prematurely filed.
But if the trial court abates it and it goes to FCHR and they find no cause, where the only kind of review is through an administrative hearing, doesn't that kind of circumvent the FCHR process model of review?
So if they issue a no-cause finding within 180, because I think that's the only circumstance where we would have to go the DOA process.
Right, you're saying because after 180, it's assumed because you can sue. But yeah, so let's just say it was the complaint was prematurely filed. The court abates it, but then FCHR within the 180 days says this is without merit and no cause, and really then the appropriate remedy is through the administrative process and not through circuit courts. How do you reconcile that?
And I might be talking a little bit off the top of my head here, so take my next answer with a grain of salt. I don't know. Obviously, if the court dismissed it and said go back to the FCHR, then we don't have to worry. We can go to the DOA, I guess, after the FCHR issues the no cause finding. If the court just debates it and doesn't dismiss, then in theory the court could then dismiss it and force us to go. If the lawsuit's not going forward, I don't know that there's any prejudice to the defendant. I don't know that I would agree that this case was prematurely filed because, again, we know now, but we didn't know, and the department didn't know back when we filed this, that there had apparently been a ball dropped between EEOC and FCHR. And I suggest if you affirmed, it would be contrary to the rule that says you don't hold plaintiffs, aggrieved civil rights plaintiffs, who've done nothing wrong on their own to facilitate this error, the ball dropping. Don't hold them accountable for the problem behind the scenes.
But FCHR is still entitled to its 180-day investigative period and conciliatory, opportunity. So if the lawsuit was filed before 180 days, regardless of whose fault it is, isn't the system, require that process, be fulfilled?
We think it should. That's the reason for the system, although two things here. One is that we didn't know what was going on behind the scenes. We didn't know that the EEOC hadn't contacted. And two, we do have, for whatever weight you want to give it, we have testimony from the highest official at the FCHR that they would have done nothing here and that they do nothing. It reminds me of what I do on Halloween night. I turn my lights out and I hide behind the curtains and wait till everybody goes away. That's what the FCHR says it would have done to us. The executive director says we wouldn't take their charge, we wouldn't investigate, we wouldn't do anything. Once the EEOC dismissed, we're done with this thing. Now, whether that's consistent with their obligations under the law or not, it's an argument for another day, but they did say we would not have done anything here. So if nothing else, you have a record on which we can safely say there's no harm and no foul here, because even the administrative agency that they hypothetically say suffered here says, no, we didn't. We wouldn't have done a thing. We wouldn't answer the phone. We wouldn't open the doors. We wouldn't turn the lights on. We would do nothing. So we're kind of right where we are if the process had worked its way out in some other path, because the Florida Commission wouldn't have done anything. And quite frankly, I don't even know. There's no way to know. There's nothing in the record. Maybe somebody from the EEOC in Miami called the FCHR and said, we're about to bounce this thing, do you want it? And they say no. I don't know. I don't know what happened behind the scenes, but what I do know is we got the piece of paper that we're supposed to get. We did everything we are supposed to do. And when we get that right to sue, like I said, that's the control tower saying it's time to take off. That's all we can do here or in any other case. And what the department would have us do is, apparently, pick up the phone and call somebody at the FCHR and say, hey, did you get the file? Is it okay if we do something here? Did you guys communicate? We didn't do that because the courts have said consistently, we're not charged with mistakes made by them, and we're not charged with responsibility to do their job. And that's our case in a nutshell. I appreciate your time. Thank you for the question.